Welcome to today's episode of Law, Technology, and Society. I'm Emma.
And I'm Daniel.
Today, we are taking on a very large and very important question. When AI, autonomous vehicles, robots, cloud systems, smart homes, drones, or other emerging digital technologies cause harm, who should be legally responsible?
And this is not a small question. It touches product liability, fault-based liability, strict liability, causation, evidence, insurance, cybercrime, data damage, and even the question of whether AI itself should have legal personality.
So this episode is going to be a full roadmap.
Exactly. We will start with the traditional logic of tort law, then explain why AI challenges that logic, and finally build a complete liability framework. Who pays, how victims prove their case, how companies share liability internally, when insurance should be compulsory, and when compensation funds may be needed.
One important clarification before we begin, the ideas we discuss today come from an expert framework on liability for emerging digital technologies. Many of these proposals are recommendations for legal reform. They should not be automatically treated as binding law in every country.
That distinction matters. We are not saying that every legal system already has identical rules. We are explaining a proposed structure for making liability law work better in the age of AI and complex digital ecosystems.
Part 1. Why AI challenges traditional tort law. Let's start with the most basic question. Why does AI create a special legal problem? People have been using tools for centuries. Cars, machines, factories, medical equipment, none of that is new.
That is true. The basic legal problem is not new. Someone uses a tool, the tool causes harm, and the law asks who should pay. But emerging digital technologies change the structure of that problem because they have several distinctive features.
Let's go through those features one by one.
The first is complexity. A modern AI system may involve hardware, sensors, software, machine learning models, cloud services, data providers, map services, wireless communication, updates, third-party plugins, platform operators, installation services, and human users.
So when something goes wrong, the accident may not be caused by one clear mistake by one clearly identifiable person.
For example, an autonomous vehicle crashes. It might be because of a sensor failure, a bad map update, a cloud connectivity problem, a flawed object recognition model, a human operator's failure to maintain the vehicle, or an unusual road condition.
Exactly. And that leads to the second feature, opacity, often called the black box problem.
With many AI systems, we can see the result. We can see that the car turned left, that the robot failed to stop, or that the system classified a patient incorrectly. But we may be difficult to explain exactly why the system produced that result.
So we know what happened, but not necessarily why it happened.
Right. The system may have processed thousands of variables, model weights, censored inputs, and real-time data streams. A victim may be able to show that the AI made a dangerous decision, but not be able to identify the exact technical cause.
What comes next?
The third feature is openness. Traditional products are often relatively fixed. A chair, a hammer, or even an old-fashioned washing machine usually stays more or less the same after it is sold.
But digital technologies can continue to change after they enter the market. They can receive software updates, security patches, algorithmic upgrades, cloud-based feature changes, new training data, revised operating parameters, new remote services. So the question is no longer simply, was the product defective when it left the factory?
Exactly. The product may become defective later because of an update, or it may become unsafe because the producer failed to provide a necessary update. The fourth feature is autonomy. AI systems may act with limited or no real-time human intervention. That creates a legal concern. Someone may say, the human did not make the final decision, the AI did.
And then the legal question becomes, did the AI break the causal link between the human actor and the harm?
That is one of the central questions. The expert approach is that autonomy should not create a responsibility vacuum. We will return to that in detail. The fifth feature is limited predictability. AI systems may encounter data or environments that were not fully anticipated when the system was designed. They may respond to unusual situations in ways that are difficult to foresee.
For example, an autonomous delivery robot sees a strange object on the sidewalk, maybe a reflective umbrella, a moving advertising screen, or a child's toy, and misclassifies it.
Yes, or a medical AI system encounters a rare combination of symptoms that did not appear in its training data.
The sixth feature is data-drivenness.
AI systems depend on data from sensors, cloud services, users, databases, cameras, maps, or external providers. If the data is missing, corrupted, biased, delayed, manipulated, or incomplete, the system may make a bad decision.
And the seventh feature is vulnerability, especially cybersecurity vulnerability.
Correct. Connected systems can be hacked. Updates can introduce security weaknesses. Sensors can be manipulated. A cyber attack may change a system's behavior without the user even realizing it.
So when we put all of this together, AI liability is difficult because we have complex systems, many actors, unclear causation, technical opacity, ongoing updates, autonomous behavior, and cybersecurity risks.
That is the starting point.
Part 2. The 3 main goals of AI liability law. Before we discuss individual legal rules, what are the broader goals? What is the liability system trying to achieve?
There are 3 major goals. First, fair and efficient loss allocation. Second, coherence and functional equivalence. Third, effective access to justice.
Let's unpack the first one, fair and efficient loss allocation.
The basic question is, when damage occurs, who should ultimately bear the loss? The answer should often depend on several ideas: who controlled the risk, who benefited from the activity, who could most cheaply reduce the risk, who could best insure against the risk, who had access to the relevant information, and who had the practical ability to prevent harm.
This sounds like the idea of the cheapest cost avoider.
Exactly. The cheapest cost avoider is the person or entity that can reduce the risk at the lowest reasonable cost. For example, imagine a company operating a fleet of autonomous delivery robots. The company can install better sensors, update software, monitor weather conditions, and restrict robots from entering dangerous areas. A pedestrian cannot do any of those things, so the company is often in a better position to prevent harm and spread its cost through insurance or pricing.
And what is the second goal, coherence and functional equivalence?
This means that similar harms should receive similar legal treatment, even if technology changes. Suppose a hospital employs a human surgical assistant. If that assistant makes a negligent error during surgery, the hospital may be liable. Now, suppose the hospital replaces the human assistant with an AI-driven surgical robot performing a similar function.
The patient should not receive weaker protection simply because the hospital automated the task.
So the principle is automation should not become a liability shield.
Exactly. The third goal is effective access to justice. A victim may theoretically have a legal claim, but that claim is useless if the victim cannot identify the defendant, cannot access evidence, cannot understand the system, cannot afford technical experts, or cannot collect damages because the liable party is insolvent. So the law must not only define liability, it must also make liability practically enforceable.
Precisely.
Part 3. Traditional tort law and the default rule. Before moving to AI-specific rules, can you explain the traditional starting point of tort law?
A traditional legal idea is often expressed in Latin as causum sentit dominus. It roughly means the loss normally lies where it falls. In other words, if your property is damaged or you suffer a loss, you generally bear it yourself unless there's a legally sufficient reason to shift the loss to someone else.
And what kinds of reasons justify shifting the loss?
The main ones are fault, strict liability, product defects, contractual obligations, vicarious liability, statutory compensation schemes, and insurance arrangements.
Let's distinguish fault liability from strict liability.
Under fault-based liability, the victim generally needs to show that the defendant acted intentionally or negligently. For example, a company may be liable because it failed to install a safety update, ignored warnings, used an unsuitable AI system, or failed to monitor a robot in a dangerous environment. Under strict liability, the victim does not necessarily need to prove fault. The focus is instead on the fact that the defendant controlled or benefited from a particularly risky activity or supplied a defective product.
So strict liability says even if you weren't personally careless, you may still have to compensate because the risk belongs to your activity.
Exactly.
Part 5. Should AI have legal personality? A question people often ask is why not make the AI itself legally responsible?
That idea is sometimes described as giving AI or robots electronic personality, but the expert view is that there is currently no need to give autonomous systems independent legal personality for liability purposes.
Why not?
Because liability is ultimately about compensation. A liable person needs assets. If a robot is liable but has no money, no insurance, and no independent assets, the victim still cannot recover anything.
So legal personality without assets would be mostly symbolic.
Yes, and if humans or companies have to give the AI money or insurance anyway, the legal system might as well identify those humans or companies directly as the relevant liability bearers.
What if the AI has a limited pool of money?
Then the risk is that AI personality creates an artificial liability cap. Imagine a highly autonomous delivery robot has a fund of 20,000 euros. It causes 1 million euros in damage. The victim receives only 20,000 euros while the companies behind the robot may try to avoid further liability. That would be problematic.
Could victims then try to pierce the electronic veil, similar to piercing the corporate veil?
That is exactly the concern. Once you create an electronic entity with limited assets, people may need legal mechanisms to look behind it and sue the human or corporate actors who created, controlled, or benefited from it. At that point, the AI personality may add complexity without solving the core problem.
So instead of asking whether the AI is a legal person, the law should ask who controlled the risk, who benefited, who designed the system, and who can compensate victims.
That is the more practical approach.
Part 5. Operator strict liability.
Let's now turn to one of the central proposals, strict liability of the operator. The basic idea is that strict liability may be appropriate where emerging digital technology is operated in non-private environments and is capable of causing significant harm. The liability should generally lie with the person who controls the operational risk and benefits from the operation. That person is called the operator.
What does operator mean here? Is it just the owner?
Not necessarily. The report deliberately prefers the flexible term operator over narrower labels like owner, user, keeper, or driver. An operator may be someone who decides whether to deploy the system, chooses where and when it operates, controls its task, monitors its performance, provides ongoing technical support, updates the system, receives revenue from the system's use, or has meaningful control over the risks created by operation.
So there can be more than one operator.
Yes, the report distinguishes between a front-end operator and a back-end operator. The front-end operator is usually the person or entity that directly deploys the technology in the real world. For example, a delivery company operating robots on sidewalks, a hospital using a surgical robot, a fleet company running autonomous taxis, a factory using industrial robots. The back-end operator is the person or entity that continuously defines important features of the system and provides essential back-end support. For example, a cloud service provider, a software company controlling updates, an AI platform provider, a company managing fleet-wide machine learning, or remote maintenance service.
Let's use an autonomous vehicle example.
Imagine an autonomous taxi. The ride-hailing company decides where the vehicle operates, when it is deployed, and which passengers it serves. That company may be the front-end operator. But the vehicle's software provider controls navigation algorithms, cloud-based driving models, fleet learning, map updates, and remote maintenance. The legal question is who has greater control over the operational risk?
And if both have meaningful control?
The law may need to specify which one is primarily liable or how liability should be shared. The report suggests that the one with greater control over the relevant operational risks should bear strict liability.
What kinds of technologies are especially suitable for strict operator liability?
Typically, technologies that move in public spaces can cause serious physical injury, expose many third parties to risk, operate with substantial autonomy, and are comparable to traditionally regulated high-risk activities. Examples include autonomous vehicles, delivery drones, public space mobile robots, some high-risk industrial robots, perhaps certain autonomous medical systems.
And what is less suitable?
Low-risk homeless technologies, such as a smart light bulb, a simple home voice assistant, or ordinary offline software, may not justify strict operator liability. Can you give a concrete example? Imagine a factory's AI-controlled heavy parts robot. A sensor malfunction causes the robot to leave the factory area and strike a passerby. Even if the factory did not act negligently, the passerby may deserve compensation from the factory because the factory operated the dangerous technology, controlled its use, and benefited from it. The factory may later seek recourse from the producer if the sensor defect originated in the product.
So strict liability does not eliminate other claims. It gives the victim a reliable first target.
Exactly.
Part 6. Traditional vehicles and autonomous vehicles.
Why do autonomous vehicles create a special issue compared to ordinary cars? With a traditional car, the owner or driver often controls speed, steering, braking, maintenance, and use. They also benefit from using the car. So traditional liability rules often make sense because the driver or owner controls much of the risk. But with a highly autonomous vehicle, especially a Level 4 or Level 5 vehicle, many important decisions may be made by software, cloud services, fleet systems, or the producer.
So the person sitting in the car may resemble a passenger more than a driver.
Exactly. And if a person cannot realistically control steering, braking, route planning, or system decisions, it may be unfair to make that person the sole responsible party. The producer, system provider, or back-end operator may be better positioned to control the relevant risk.
And the report also warns that traditional defenses may not fit autonomous technology.
Yes, some traffic liability systems are built around ideas like human control, driver fault, unavoidable events, or the driver's ability to prevent an accident. But where there is no meaningful human driver control, those defenses may no longer fit. The legal analysis should shift towards questions such as who designed the automated driving system, who controls the updates, who maintains the software, who manages the fleet, who has access to logs and technical data.
Part 7. Producer strict liability.
Now let's turn to the producer. What is the main idea behind producer strict liability? The producer should play a central role where harm is caused by defective products or defective components, whether tangible or digital. This includes physical hardware, sensors, software, AI models, digital content, cloud-dependent functionality, updates, cybersecurity mechanisms, and digital services connected to the product.
So a defective may not be limited to a broken physical part.
Exactly. A defective software update may be just as dangerous as a broken brake pedal.
What happens when a product becomes defective after it has entered the market?
That is one of the major issues for digital technology. Traditionally, product liability often focuses on whether the product was defective when it was put into circulation. But if the producer continues to control updates, upgrades, cloud services, or remote functionality, the producer may remain responsible for defects that arise later.
Can you give examples?
Certainly. A producer may be responsible if a software update creates a dangerous braking error in an autonomous vehicle. A cloud navigation service sends a robot into an unsafe area. The producer fails to provide a necessary security update. An AI medical device becomes unsafe because its model is not properly maintained. Or the producer continues to operate a digital service essential to the product's safe functioning.
And what about the development risk defense?
The development risk defense usually means that a producer may argue that the defect could not have been discovered using the scientific and technical knowledge available at the time. But the expert framework is cautious about allowing that defense for highly dynamic, open, self-learning, and connected technologies. The argument is not that producers must predict every exact future problem. The argument is that if it was foreseeable that a system would evolve, learn, interact with external data, receive updates, or face cybersecurity threats, then the producer should not automatically escape liability by saying, "We did not know this exact harm would occur."
So the foreseeable uncertainty of the system itself may matter.
Exactly.
Part 8. Why producer liability is justified.
Why should producers bear strict liability for defective digital technology? There are several reasons. First, producers usually have the best access to information about design, testing, model behavior, security vulnerabilities, known defects, update history, internal reports, and incident data. Second, producers can often spread accident costs through product prices and insurance. Third, producers' liability creates incentives for safer design, more testing, better documentation, post-market monitoring, timely updates, effective warning systems, and cybersecurity measures. Fourth, there is a functional equivalency argument. If digital content performs the same function that a tangible product component performed in the past, it should not escape liability merely because it is intangible.
For example, if a physical brake part was defective, product liability might apply. If the brake failure is caused by a defective braking software, similar protection should exist.
Exactly.
Part 9. Fault-based liability of producers. Strict liability is one route, but what about producer fault liability?
Producer fault liability applies when the producer has intentionally or negligently breached a duty of care. The product is the direct instrument causing harm, but the dangerous feature may result from the producer's negligence in designing, manufacturing, testing, marketing, documenting, warning, monitoring, updating, repairing, or securing the product.
So the victim may need to prove two things: that the product was below the required quality level and that the producer intentionally or negligently breached an applicable standard of conduct.
Correct. For example, suppose a producer knows that a smart medical device can malfunction after a specific update, but does not warn hospitals or release a corrective patch. The victim may argue that the product was not sufficiently safe and the producer negligently failed to monitor, warn, or update it.
Why is this especially difficult in AI cases?
Because the victim may need to prove what quality and safety level the product should have met, how the system actually operated during the accident, what the producer knew, what monitoring should have occurred, whether the producer received warnings, whether internal tests identified the risk, whether a reasonable producer would have acted differently. Much of this information is inside the producer's organization.
Part 10. Fault-based liability of users and operators.
Now let's look at the liability of the person using AI or another digital tool.
The traditional structure is actor plus use of a tool, act, causation, damage. Then the law asks whether the actor acted wrongfully or with fault, and whether a legally protected interest was harmed.
What does the fault analysis look like?
The report breaks it down into 4 decisions. First, was the decision to act itself wrong? Second, was the decision to use a tool wrong? Third, was the choice of tool wrong? Fourth, was the way of using, controlling, or monitoring the tool wrong?
Let's take them one by one.
First, the decision to act. Suppose a company decides to operate delivery drones during a severe storm. Even before discussing the drone's technical performance, the decision to carry out deliveries may be itself unreasonable.
Second, the decision to use a tool. Suppose a hospital decides to use an AI surgical robot for an extremely unusual procedure, even though the system is not designed for that type of surgery. The problem may be the decision to use the tool at all.
Third, the choice of tool. Suppose a company chooses a low-accuracy AI recognition system for a high-risk security task, or a factory chooses a robot not designed for crowded environments.
Fourth, the way the tool is used, controlled, or monitored. Suppose an operator ignores repeated warnings, fails to install a safety update, fails to maintain sensors, or does not stop the system when dangerous conditions arise.
So an operator or user can be at fault even if the technology itself is not defective.
Exactly. And the opposite is also true. The technology may be defective even if the operator was careful. That is why strict liability, product liability, and fault liability can coexist.
Part 11. Illustration: the drone in the storm. Can we use a simple example to show the difference between strict liability and fault liability?
Let's use a delivery drone. A retailer operates an AI-controlled delivery drone. A weather warning predicts strong winds. The retailer continues delivery operations. The drone crashes and injures a passerby. There may be several possible claims.
First, the retailer may face strict liability as the operator of a risky technology. Second, the retailer may face fault liability because it failed to suspend operations during foreseeable dangerous weather. Third, the drone producer may be liable if the drone had a defect. Fourth, a software provider may be liable if a faulty update caused the drone to misread wind conditions.
So one accident can generate several liability pathways.
Yes, and the victim should not necessarily have to choose only one. Part 12. Duties of care of operators.
What specific duties should operators have?
The report identifies three main categories. First, the duty to select the right system for the right task. Second, the duty to monitor the system. Third, the duty to maintain the system.
What does selecting the right system mean in practice?
It means the operator must consider the task, the environment, the system's limitations, the skill of staff, the need for human supervision, foreseeable risks, and whether the technology is suitable for the intended use.
And monitoring?
Monitoring may involve watching system alerts, supervising performance, checking environmental conditions, reviewing anomalous outputs, monitoring cybersecurity, ensuring staff are trained, and responding to warnings.
And maintenance?
Maintenance includes more than physical repair. For digital systems, it may include software updates, security patches, sensor calibration, model performance checks, data quality checks, hardware maintenance, and periodic safety testing. Part 13. Duties of care of producers.
What about producers? What are their fault-based duties?
Producers should design, describe, and market their products in a way that enables operators to use them safely. That means producers should provide clear instructions, warnings about limits, information about safe operating conditions, training where needed, information about known risks, and effective methods for monitoring and maintaining the system. Producers should also monitor their products after they enter the market.
Can you give an example?
Imagine an aircraft producer introduces a new AI-assisted autopilot function. In exceptional conditions, the system may need to be manually disabled by the pilot. The airline that uses the aircraft has duties too. It should understand the feature, train pilots, monitor the aircraft, share safety information, and develop procedures for emergencies.
But the producer must also explain the risk, provide proper warnings, offer training, monitor real-world performance, and issue updates if necessary.
So the operator and producer have different but complementary responsibilities.
Exactly.
Part 14. Vicarious liability and AI replacing human assistance.
Now let's discuss vicarious liability. This is one of the most interesting parts.
Vicarious liability means that one person or organization can be liable for harm caused by another person, often because that person acts as an employee, assistant, or auxiliary. The expert framework asks, what happens when AI or autonomous technology replaces a human assistant?
And the answer is that the organization should not avoid liability simply by replacing people with machines.
Correct. Suppose a hospital uses an AI surgical robot instead of a human surgical assistant. If a human assistant would have created liability for the hospital, then replacing the assistant with autonomous technology should not reduce the patient's protection.
What if the hospital did everything reasonably possible? It selected a good system, trained staff, maintained the robot, and monitored it, but the robot still malfunctions in an unforeseeable way.
That is exactly the kind of situation where the report sees a potential need for liability analogous to vicarious liability. The hospital used the robot to perform a function that could otherwise have been performed by a human assistant. The patient should not be left uncompensated merely because the harm was caused by a machine rather than an employee.
Would that mean the robot is treated as an employee?
No, the robot is not literally an employee. The point is functional equivalency. The law should ask, if a human auxiliary had performed this task and caused comparable harm, would the principal, such as the hospital, have been liable? If yes, using AI should not reduce the victim's protection.
Then how should courts decide whether AI performance was inadequate?
The framework suggests a dynamic benchmark. At first, the AI might be compared with a reasonably competent human auxiliary. For example, if a surgical robot makes a cut twice as long as a competent human surgeon would normally make, that strongly suggests deficient performance.
But what if the robot is still better than a human, even though it's worse than the best available robot?
Then the question shifts from robot performance to whether the hospital should have bought the better robot.
Exactly. The court would consider the risk level, the cost of the better system, its availability, the hospital's resources, the nature of the procedure, the expected safety gain, and possible alternatives.
The law should not automatically require everyone to buy the most advanced technology on the market, but it should ask whether a reasonable operator should have used better available technology in that specific situation. Part 16. Logging by design.
Let's move to evidence. One of the most practical proposals is logging by design.
Yes, logging by design means that high-risk digital technologies should be designed with the ability to record relevant operational information. The goal is not surveillance for its own sake. The goal is to make accidents understandable and legally accessible.
What kinds of data might need to be logged?
Potentially, sensor inputs, camera and radar readings, system status, AI outputs, decision paths, software version, update history, human override actions, emergency warnings, communication between systems, location and timing data, maintenance events, and cybersecurity alerts.
Would all technologies need the same logging requirements?
No, logging must be appropriate and proportionate. The law should consider technical feasibility, cost, the seriousness of the risk, whether other evidence is available, data protection, privacy, trade secrets, and the rights of other people.
Give us a contrast.
An autonomous vehicle operating in public traffic may need extensive logging because accidents can cause serious physical harm and logs can help reconstruct events. But an AI children's toy may not need to record conversations. Recording children's private speech could create serious privacy problems that outweigh the evidentiary benefit.
What happens if a system should have logged information but did not?
The report suggests a rebuttable presumption.
If the producer failed to provide required logging or the operator refuses to give reasonable access to existing logs, the court may presume that the missing information would have supported the victim's claim.
So the burden shifts because the party controlling the evidence failed to preserve or disclose it.
Exactly.
Part 17. Illustration. Two autonomous vehicles collide. Can we use the two autonomous vehicle example?
Certainly. Suppose autonomous vehicle A and autonomous vehicle B collide while communicating about lane entry. Vehicle B's passenger is injured. Vehicle A refuses to disclose its logs. If the logs would be important to determine whether Vehicle A told Vehicle B to enter first and then entered the lane itself, the court may presume that the missing logs would have shown the facts unfavorable to A.
And what if the vehicle did not have logging capability at all?
Then the issue may shift toward the producer. If the vehicle should have had a logging system but lacked one because of the producer's design and the operator suffers liability because it cannot disclose evidence, the operator may seek recourse from the producer.
Part 18. Safety rules and their evidentiary effect. How do formal safety rules fit into this framework?
If a person violates a safety rule and the damage that occurs is the kind of damage the rule was intended to prevent, the burden of proof may be reversed regarding causation, fault, and/or the existence of a defect.
Can you give an example involving cybersecurity?
Imagine a legally binding cybersecurity requirement for internet-connected household devices. The requirement exists to prevent hacking. A smart water kettle fails to comply with the required security standard, a hacker uses the vulnerability to enter the home network and causes damage. The producer may then have to prove that the damage was caused by another device or another independent cause.
What kinds of standards count?
The report emphasizes legally binding standards adopted by lawmakers or competent authorities. Industry standards may still be relevant to the duty of care, but they do not automatically have the same strong burden-shifting effect.
And compliance with a safety rule does not automatically prove that the producer or operator was not at fault.
Correct. Technology evolves quickly. Formal standards may lag behind real risks. A company may comply with minimal rules but still fail to act reasonably under the circumstances.
Part 19. Causation and the AI black box. Causation is often the hardest part in technology cases. How does the framework handle it?
The starting point remains that the claimant must prove causation. But in AI cases, proving causation may be extremely difficult because the victim may not know how the system processed input data, why it produced a particular output, whether the harm came from hardware, software, data, updates, maintenance, or cybersecurity, whether there were multiple contributing causes, or whether the key evidence is hidden inside the defendant's systems.
So the law may need to alleviate the burden.
Yes. The report suggests several factors that can justify easing the burden of proving causation. For example, how likely is it that the technology contributed to the harm? Is the likely cause within the defendant's sphere of control? Is there a known defect or known risk linked to the kind of harm that occurred? How traceable and intelligible is the technical process after the event? Who controls the evidence and has the ability to interpret it? How serious is the actual or potential harm?
Can you explain the difference between easing the burden and fully reversing it?
Certainly. Easing the burden may mean the victim can rely on plausible inferences, circumstantial evidence, a lower threshold of proof, or a prima facie case. Reversing the burden means the defendant may need to prove that the technology did not cause the harm or that another cause was responsible. Part 20.
Evidentiary tools. What kinds of legal tools can courts use?
Several. First, prima facie evidence. This means the claimant provides enough evidence to create an initial inference. Then the defendant must respond with an explanation or counter-evidence. Second, res ipsa loquitur. This is a common law phrase meaning the thing speaks for itself. If an accident is of a type that ordinarily would not happen without negligence, the accident itself may support an inference of fault. Third, presumptions in fact. A court may infer one fact from another. Fourth, adverse inference. If a defendant controls important evidence, such as internal reports, logs, technical documentation, or design plans, but fails to disclose it, the court may infer that the evidence would have been unfavorable to the defendant. Fifth, a shift in the burden of producing evidence. The claimant may establish a sufficiently strong initial case, whereafter the defendant must produce evidence to rebut it.
That is different from a complete shift of the ultimate burden of proof.
Exactly. The legal system can use different levels of adjustment depending on the case.
Part 21. Illustration. The delivery robot, with multiple possible causes. Can we use the delivery robot to explain multiple causes?
Certainly. Imagine a delivery robot injures a pedestrian. Possible causes include an original product defect, the retailer's failure to install a safety update, an employee overloading the robot, a hacker manipulating the system, teenagers jumping on the robot, or an unrelated external event, such as a falling roof tile. The victim may not know which cause is responsible. If the causes attributable to the retailer's sphere are collectively much more likely than the external causes, the retailer may be required to explain or disprove the claim.
And hacking may not always be treated as a completely external cause.
Correct. If hacking was foreseeable, if the system had known cybersecurity weaknesses, or if the operator failed to install security updates, hacking may still fall within the operator's or producer's risk sphere.
Part 22. Fault and the burden of proof. Now let's come back to fault. What exactly must a claimant prove in a normal fault-based claim?
In theory, the claimant must prove the applicable standard of care, that the defendant breached that standard, that the breach was intentional or negligent, causation, and damage.
And what is difficult about determining the standard of care?
If the standard is not clearly set by statute, regulation, or binding rules, the claimant may need to persuade the court what a reasonable standard should have been. For example, should the operator have installed a specific update? Should a hospital have used a different robot? Should a delivery company have suspended services at a certain wind speed? Should a producer have used stronger cybersecurity measures? Should a platform have monitored model drift more closely? The victim may not have the technical knowledge or internal information needed to answer these questions. So the lack of a clear standard puts the claimant at a disadvantage. Exactly. The report therefore asks whether some of the evidentiary difficulties should be shifted to the defendant.
Part 23. What might be shifted to the defendant? What kinds of facts might the defendant have to prove or explain?
Potentially, whether the producer or operator breached a duty of care, whether the defendant acted intentionally or negligently, whether the technology was below the required quality standard, whether the technology malfunctioned, whether the operator selected the right technology, whether the operator monitored and maintained the system properly, whether the producer performed adequate testing and post-market monitoring.
What factors justify changing the burden of proof?
The report identifies several. First, a high likelihood of fault. Second, the party's practical ability to prove fault. Third, violation of a statutory obligation. Fourth, the particular dangerousness of the activity. Fifth, the nature and scope of the damage.
So, if the defendant controls the logs, code, testing records, maintenance records, and internal expertise, the information asymmetry itself can justify burden shifting.
Yes, that asymmetry is crucial. The victim may only see the accident. The producer or operator may possess the entire technical story.
Part 25. The victim's own sphere and contributory conduct. We have talked a lot about defendants, but what if the victim's own behavior or technology contributed to the harm?
Then the victim's claim may be reduced and, in extreme cases, possibly excluded. The key idea is called the mirror image rule of contributory conduct.
What does mirror image mean here?
It means that the same kinds of questions used to determine the defendant's responsibility should also be used to determine whether the victim's own sphere contributed to the harm. For example, who controlled the victim's technology? Who benefited from its operation? Who chose the system? Who maintained it? Who updated it? Who monitored it? Did the victim's own system create or contribute to the risk?
Can you use two autonomous vehicles again?
Suppose autonomous vehicle A collides with autonomous vehicle B. B's passenger is injured and claims compensation from A's operator. But B's own vehicle may also have contributed because B's operator failed to install a safety update. B's sensors were defective. B's backend provider failed to update maps. B's vehicle entered the lane incorrectly. B's operator ignored warnings. Then, the victim's claim against A may be reduced to reflect the contribution of B's own vehicle and its operators.
So the victim is not always personally blameworthy. The victim's own technological sphere may still matter.
Exactly. The issue is broader than personal moral blame. It includes risks within the victim's control or operational sphere.
Part 25. Commercial and technological units.
Now we come to one of the most important ideas for digital ecosystems, commercial and technological units.
Yes, this is designed to solve a major problem. Modern digital systems are often made up of multiple providers: a hardware manufacturer, a software provider, a cloud provider, a platform, an installer, a connectivity provider, a data provider, and a maintenance service.
A victim may know that the overall system caused harm but may not be able to prove which component failed.
And that creates the risk of suing the wrong party.
Exactly. The victim may bring a costly lawsuit against the hardware producer only to be told the failure came from the cloud service. Then the cloud provider may say the problem came from software. Then the software provider may blame the installer. The victim may end up with no compensation and huge litigation costs.
So what is the proposed solution?
Where two or more persons cooperate on a contractual or similar basis to provide different elements of one commercial and technological unit, and the victim can prove that at least one element caused the damage in a liability triggering way, but cannot prove which element, all potential tortfeasors should be jointly and severally liable to the victim.
That means the victim can claim the full amount from any one of them.
Yes, subject to the total compensation not exceeding the total damage.
Part 26. How do we identify a commercial and technological unit?
What factors determine whether a group of companies form such a unit? There are three main factors. First, joint or coordinated marketing. Do the companies present their products or services to consumers as a unified solution? Second, technical interdependency and interoperation. Do the components depend on one another and need to exchange information or cooperate to perform their core function? Third, specificity or exclusivity of the combination. Are the components specially designed to work together? Are they difficult to replace with other components? Is the combination a closed or highly integrated ecosystem?
Let's use the smart home alarm example.
Imagine A makes the smart alarm, B makes the smart home hub, C installs and configures the system, D provides the cloud ecosystem. A burglary occurs. The alarm does not properly notify the police. Major losses result. Suppose it can be shown that the problem was not caused by C's installation and not caused by an external event, but it remains unclear whether the failure came from A's alarm, B's hub, or D's cloud ecosystem. If A, B, and D have sophisticated contractual arrangements, their components are designed to interoperate, and they jointly market the system, the homeowner should be able to sue them jointly.
And then A, B, and D can sort out the internal responsibility later.
Exactly.
Part 27. Why this rule is needed.
What is the policy justification for this rule? There are several. First, without this rule, victims may be seriously undercompensated compared to earlier, functionally equivalent situations. In the past, a traditional alarm system might have been produced by a single identifiable manufacturer. The homeowner could sue that manufacturer. Now, the same function may be split across many firms. The victim should not receive weaker protection simply because the product became digital and modular.
Second, the rule prevents false incentives. Providers should not be able to artificially split an integrated ecosystem into separate legal components merely to obscure causal links and dilute responsibility.
Third, the victim should not bear the risk of the provider's internal business structure. If the system could just as well have been provided by one company, the fact that the companies chose to divide the work should not make compensation harder. Fourth, it's efficient. The providers are in the best position to manage interaction and interoperability risks, negotiate contracts, allocate responsibilities, buy insurance, preserve logs, and agree in advance how accident costs will be shared.
Part 28. The boundary case. The network provider.
Part 28. The boundary case. The network provider.
Does every service connected to the system become part of the commercial and technological unit? No, that would be too broad. Consider a network provider, E. The smart home system fails because the internet connection is temporarily interrupted. Normally, smart home equipment merely needs internet connectivity. It does not need connectivity from one specific network provider. Consumers generally do not expect the smart home manufacturers and the ordinary network provider to be specially coordinated. So E would usually not be part of the commercial and technological unit.
But there could be an exception.
Yes, if E's network service was marketed as a special, highly reliable, integrated part of the smart home security package, then the situation might be different. For example, if the companies advertise, "Our smart home alarm ecosystem includes a dedicated, high-reliability network service that ensures emergency alerts will always reach the police," then the network provider may become part of the integrated unit.
Part 29. Multiple tortfeasors and redress. We've discussed the victim's right to claim compensation, but what happens after one party pays?
That is the redress stage. We need to distinguish two levels. At the first level, liability towards the victim is often joint and several. At the second level, the parties redistribute the loss among themselves.
So, towards the victim, several responsible parties may be jointly liable.
Correct. If A, B, and C all contributed to the same damage, the victim may request the full amount from any one of them. But once one party has paid, that party may seek redress from the others. Normally, redress is based on identified shares. That means each party should ultimately pay only its individual share of responsibility.
Can you give an example?
Suppose a hospital pays a patient 100,000 euros. Later, it is determined that the hospital itself should bear 20%, the surgeon should bear 30%, and the robot producer should bear 50%. The hospital should ultimately bear 20,000 euros and may seek 30,000 euros from the surgeon and 50,000 euros from the producer.
Part 30. Alternative causation.
What happens if it's unclear who actually caused the harm?
That is the classic problem of alternative causation. Imagine a patient's artery is cut during a surgery involving an AI-driven surgical robot. The injury may have been caused either by the surgeon making the wrong movement or the robot incorrectly executing a correct movement. The victim knows that one of those causes must have caused the harm, but cannot prove which one.
Why does the normal but-for test create a problem?
The traditional conditio sine qua non, or but-for test, asks, but for this event, would the harm have occurred? If we remove the surgeon's error from the hypothetical story, the robot's error may still have caused the injury. If we remove the robot's error, the surgeon's error may still have caused the injury. So neither cause appears to be the sole necessary cause.
And then, absurdly, neither the surgeon nor the robot-related defendant may be held liable, even though we know one of them caused the injury.
Exactly. That would be a serious justice failure. The victim could end up with no compensation even though it's certain that one of the potential causes actually caused the damage.
Part 31. Commercial and technological units at the redress stage.
How does the commercial and technological unit idea work at the redress stage? Suppose an external tortfeasor has already paid the victim. That paying tortfeasor now seeks redress from a group of providers, for example, a hardware producer, a software provider, and cloud service providers. Those providers may form a commercial or technological unit. The paying tortfeasor may know that the unit is collectively responsible for, say, 70% of the damage, but it may not be able to identify how much of that 70% belongs to hardware, software, or cloud services. In that case, the members of the unit should be jointly and severally liable for the unit's cumulative share.
So if the unit's total share is 70%, the paying tortfeasor can recover that 70% from any one of the unit members.
Yes, the unit members can then resolve their internal shares among themselves. This prevents a second responsibility vacuum. The first vacuum would be that the victim cannot identify the right defendant. The second vacuum would be that the paying tortfeasor cannot identify the right internal contributor. The report seeks to avoid both.
Part 32. Damage to data.
Now let's move to a different subject, damage to data. This is increasingly important because so much of modern life is digital. Data damage may involve deletion, deterioration, contamination, encryption, alteration, suppression, corruption, loss of access, or making data unreadable.
Why is data damage legally difficult?
Because traditional tort law was built around tangible property. If someone breaks your hard drive, it's relatively easy to say your tangible property was damaged. But what if your files are stored in a cloud server owned by someone else? You may be the person who loses the data, but you don't own the physical server.
So damage to the server may give a cloud provider a claim, while the user who loses the data may struggle to find a legal basis.
Exactly. Damage to the server may give the cloud provider a claim, while the user who loses the data may struggle to find a legal basis.
Part 33. 4 main bases for liability for data damage. What are the main bases for liability where data is damaged?
The framework identifies 4 main possibilities. First, contractual liability. If a cloud provider, platform, or service provider breaches a contractual duty to protect data, the user may claim damages. Second, liability may arise from interference with the property right in the medium where the data is stored, or with another legally protected interest sufficiently similar to property. Third, liability may arise from conduct that violates criminal law or other legally binding rules intended to prevent that kind of data damage. Fourth, liability may arise where the tortfeasor intended to cause harm.
Part 34. Contractual liability for data damage.
Give us a contractual example.
Suppose A stores all of her files in cloud space provided by C under a contract. C fails to properly secure the cloud account. A hacker enters the account and deletes all of A's photos. C may normally be liable to A on a contractual basis because C failed to provide reasonable security.
What kind of damages might A recover?
At a minimum, economic losses such as data recovery costs, restoration expenses, replacement storage costs, cost of rebuilding records, business interruption losses where applicable, and reasonable cybersecurity remediation costs. Whether A can recover compensation for the emotional loss associated with losing irreplaceable family memories depends on the relevant national legal system.
So the economic loss is easier to recognize. Non-economic loss may vary.
Exactly.
Part 35, the physical medium approach.
What happens where there is no contract?
Some legal systems have historically dealt with data damage by treating it as damage to the physical medium on which the data is stored. For example, A stores files on a hard drive in her home computer. Neighbor B negligently damages the computer. The hard drive becomes unusable and the files cannot be read. Even if the law is uncertain about whether data itself is property, B has clearly damaged A's tangible property, the computer and hard drive, so B may be liable on that basis.
But the problem appears when the owner of the storage medium is not the same person as the person with the important interest in the data.
Exactly. Suppose A stores files on cloud servers owned by C. B negligently damages C's servers. A's files are deleted. C owns the servers, but A is the person who loses the data. The physical medium approach may not adequately protect A.
Part 36. Why intellectual property is not the full answer.
Could the law solve this by saying that data is protected whenever it has copyright or another intellectual property right? The report considers that possibility but rejects it as the main solution. Intellectual property rights protect intellectual achievement, creative expression, investment, confidential information, or innovation. But the question in data damage is different. Why should particular copy of particular data be protected from destruction? Consider 3 examples. First, A stores photos that A took herself. A may own the copyright. Second, A stores photos taken by someone else. A may not own the copyright, but A still has a strong personal interest in preserving them. Third, A stores valuable machine data from industrial sensors. The data may have enormous economic value, but no one may own copyright in it. It would make little sense if liability depended entirely on whether copyright exists.
So the injury is the destruction of data that A controls, uses, values, or depends on, not necessarily an infringement of creative ownership.
Exactly.
Part 37. Protected legal interests and third-party effect.
If intellectual property is not enough, what other legal interests might matter?
Some legal systems may recognize other interests that have effect against third parties, not only against contractual partners. One example is possession. The idea is that a person may have a legally protected relationship to data because they control it, use it, depend on it, or have a recognized right to exclude others from interfering with it. But this depends heavily on the applicable national legal system.
So the report does not claim that every type of data is automatically property.
Correct. It says that being sufficiently akin to property is one possible justification for tort protection, but not the only one.
Part 38. Criminal conduct and data damage.
What about hacking?
Hacking is a clearer case. If B hacks into A's cloud account and deletes A's files, that normally amounts to criminal conduct. B should be liable. The important point is that liability can be grounded in the wrongful conduct itself, especially where the conduct violates criminal law, cybersecurity rules, or other legally binding norms designed to prevent data damage.
So the legal basis may be violation of a rule designed to prevent data harm, plus actual data damage equals possible civil liability.
Exactly. The report points to the importance of laws that clearly state their purpose. It uses the GDPR as an example because Article 82 expressly provides for liability where damage results from an infringement of GDPR requirements.
But GDPR is mainly about personal data, not all valuable data.
Correct. GDPR is an example of a clear legal link between regulatory violation and compensation. It is not a universal solution for every form of data damage.
Part 39. Avoiding overbroad data liability.
Why not simply create a broad rule saying no one may access or modify data controlled by another?
Because data is everywhere. People constantly access, copy, modify, transmit, and process data controlled by others. Employees use company databases. People collaborate and share documents. Apps synchronize contacts. Websites process user data. Cloud services move files. APIs exchange information. Smart home systems communicate with platforms. AI services process input data. A rule that broadly prohibited all access or modification of another person's data could create excessive liability risks.
So the law must distinguish authorized and ordinary data processing from wrongful interference.
Exactly. Relevant questions include, was the access unauthorized? Was there intentional harm? Was there negligence? Was a legal duty violated? Did actual damage occur? Was the rule intended to protect against that type of harm?
Part 40. Intentional data damage.
The final basis is intention to cause harm.
Yes, most legal systems would agree that if someone intentionally deletes, encrypts, corrupts, alters, or suppresses another person's data in order to cause harm, liability should follow. This is the strongest and least controversial basis. Examples include ransomware attacks, revenge deletion by an employee, deliberate alteration of medical records, intentional destruction of business data, sabotage of industrial sensor data, intentional manipulation of AI training data.
Part 41. Insurance.
Let's move to insurance. When should liability insurance be compulsory for emerging digital technologies?
The core idea is the more frequent or severe the harm, the less likely the operator can compensate victims individually, the more suitable compulsory liability insurance may be.
So the two main variables are severity or frequency of harm and the operator's ability to pay.
Exactly. Mandatory liability insurance is often associated with strict liability regimes because the person who the risk is attributable may have to compensate victims even without fault.
The traditional explanation is protection against insolvency.
Yes, the aim is to prevent a situation where the victim has a valid legal claim, but the responsible person is bankrupt or has insufficient assets.
But there is also an economic explanation. Insurance helps internalize the costs of risky activities.
Meaning that the person or company benefiting from the activity has to include accident costs in its business model.
Exactly. If a company operates autonomous delivery robots, it earns revenue from the service. The insurance premium makes the company account for the risk of harming others. This creates incentives to improve safety, reduce accidents, choose safer operating environments, monitor systems, install updates, and avoid reckless deployment.
Part 42. Why mandatory insurance should not be automatic.
Does every AI system need compulsory insurance?
No, the report strongly rejects automatic rules based merely on labels like AI, robot, or digital technology.
The law should carefully ask, is the risk significant? Is the harm likely to be serious? Is the harm likely to occur frequently? Are third parties exposed? Can the operator compensate from their own funds? Are other financial guarantees available? Can insurers reasonably price the risk?
And why might insurance not be available?
New technologies may lack historical data. Insurers may not know how often accidents will happen, how severe they will be, or what legal liabilities will arise. If the risk cannot be calculated, insurers may refuse to underwrite it.
And then a mandatory insurance rule could block deployment.
Exactly. If the law requires proof of insurance before a technology can operate, but no insurer is willing to cover the unknown risk, the technology may be unable to enter the market at all.
Part 43. Alternatives and supplements to insurance.
What alternatives are available if normal insurance is difficult?
Several possibilities exist. One is a liability cap, a legally predetermined maximum amount of liability, adjusted over time. That may make risk more predictable for insurers. Another possibility is a broader requirement of financial security, not necessarily insurance.
Examples include bank guarantees, deposits, parent company guarantees, dedicated compensation reserves, industry funds, self-insurance arrangements, or other financial securities.
But liability caps can also create undercompensation for victims.
Exactly. They may make insurance possible, but if the cap is too low, victims may receive less than full compensation, so the design must be careful.
Part 44. When insurance is most suitable.
Which sectors are most suitable for compulsory liability insurance?
The report points to sectors such as transportation, industries with significant personal injury risks, activities with environmental risks, hazardous activities, and certain professional sectors. For emerging technologies, this may include autonomous vehicles, public space delivery robots, drones, high-risk industrial systems, some medical AI technologies, autonomous infrastructure systems, and other technologies that can seriously harm people or the environment.
And in motor traffic-like situations, victims may even be allowed to claim directly against the insurer.
Yes, a direct action against the insurer can be especially valuable where the victim is a third party with no contract with the operator. It can protect victims if the operator is insolvent, disappears, refuses to cooperate, or disputes liability.
Part 45. Compensation funds.
Finally, let's discuss compensation funds. What are they for?
Compensation funds are a last resort safety net. They may protect tort victims who are legally entitled to compensation but cannot actually obtain it.
So first, the victim must have a valid claim under ordinary liability rules.
Exactly. A compensation fund is not meant to replace strict liability, fault liability, product liability, insurance, or normal litigation. It comes into play when the ordinary system cannot satisfy the claim.
Part 46. Why does the report not recommend a universal compensation fund for all AI harm?
Because if producer strict liability, operator strict liability, fault liability, insurance, and internal recourse work properly, there should be no need to socialize all AI-related losses through a public or institutional fund. A general AI fund could create problems. Companies may externalize risks to society. Safety incentives may weaken. Public funding burdens may grow. Boundaries may become unclear, and the system may reduce pressure on producers and operators to manage risks properly.
So the preferred structure is still responsible actor pays, insurance supports payment, internal recourse allocates the final burden, fund only fills the remaining gap.
Exactly.
Part 47. Unidentified and uninsured technology. When might a compensation fund be appropriate?
Especially where compulsory liability insurance exists. For example, if an autonomous vehicle, delivery drone, or mobile robot causes damage, but the responsible operator cannot be identified, the technology is uninsured, the insurance is invalid, the liable person is insolvent, or the responsible entity cannot be found, then a compensation fund may protect the victim.
This resembles motor insurance compensation systems.
Yes, the motor insurance model is often used as a reference because it addresses cases involving unidentified or uninsured vehicles. The same logic may be relevant for certain high-risk autonomous technologies.
Part 48. Cybercrime and non-fault compensation. Why does the report treat cybercrime specially?
Because hacking is a serious threat to software-based technologies, but traditional tort law may fail in practice. Victims may not be able to identify the hacker. The hacker may be abroad, anonymous, insolvent, or impossible to sue. If cybercrime causes serious personal injury, the report suggests that a non-fault compensation scheme similar to compensation for victims of violent crime may be appropriate.
Can you give examples?
Imagine a hacker takes control of an autonomous medical delivery robot and seriously injures a patient. A cyber attack causes an autonomous vehicle crash. An attacker manipulates an industrial control system, causing an explosion. A cyber attack disables a safety system and causes severe physical injury. In such cases, if the attacker cannot be identified or sued, victims with serious personal injuries could potentially be treated similarly to victims of violent crime.
So this is not about every minor cyber incident.
Correct. It is about serious cybercrime that produces serious harms comparable to serious violent crime, especially serious personal injury.
Part 49. A full integrated case study. Let's finish with one integrated example. Let's imagine a smart autonomous medical delivery system in a hospital.
Good idea. Suppose a hospital uses autonomous robots to deliver medication and medical devices between departments. The system includes hardware robots made by Company H, navigation software made by Company S, cloud-based route optimization from Company C, hospital deployment and monitoring, wireless connectivity from provider N, periodic software updates, and an AI system that prioritizes emergency deliveries. One day, a robot carries a heavy medical device through a corridor, it misidentifies a person, fails to stop, and causes serious injury.
Where do we begin?
Step 1. Identify possible liability bases. The hospital may be strictly liable as an operator because it deploys the robot in a non-private environment and benefits from its use. The producer H may be strictly liable if the robot has a defect. The software provider S may be liable if the navigation system is defective. The cloud provider C may be liable if a cloud update or routing error caused the malfunction. The hospital may also be liable for fault if it failed to monitor, maintain, update, or deploy the robot safely.
And what about vicarious liability?
If the robot functionally replaces human hospital staff who would otherwise transport equipment, the hospital should not escape responsibility merely because the task is automated.
What evidence will matter?
Logs. We would want to know what sensors detected, what the AI classified, what navigation command was issued, what software version was running, whether updates were installed, whether there were warnings, whether a human override was available, whether the hospital had previously observed similar failures. whether cybersecurity anomalies occurred.
What if logs are missing?
If logging should have existed but didn't, or if the hospital or producer refuses reasonable access, the court may apply a rebuttable presumption that the missing evidence would have supported the victim.
And what if the system involved several providers and nobody knows whether the fault lies in hardware, software, or cloud routing?
Then we ask whether H, S, and C form a commercial and technological unit. If they have contractual cooperation, tightly integrated components, coordinated marketing, and a system designed to operate together, the victim may be able to sue them jointly and severally.
And what if the victim already paid the hospital?
The hospital may seek redress. If H, S, and C form a commercial and technological unit, the hospital may be able to recover the unit's cumulative share from any of them, even if it cannot precisely divide responsibility inside the unit.
And what if the injury was caused by a hacker?
Then we need to ask, was hacking foreseeable? Were cybersecurity duties breached? Was a mandatory security rule violated? Did the producer provide necessary updates? Did the hospital install them? Can the hacker be identified? If the hacker cannot be identified and the cyber attack causes serious personal injury, a compensation fund or non-fault compensation scheme may become relevant as a last resort.
And what if the robot was uninsured?
If compulsory liability insurance applied, a compensation fund could potentially protect the victim when the technology or operator was uninsured.
Part 50, the final master checklist. Before we close, can you give us a final checklist for analyzing any AI liability problem?
Yes, here's a structured approach. First, identify the harm. Was there personal injury, property damage, economic loss, environmental damage, data damage, non-economic loss? Second, identify the technology. Is it autonomous? Is it connected? Is it self-learning? Does it operate in public space? Does it receive updates? Does it depend on cloud services? Does it create cybersecurity risks? Third, identify the possible defendants. Operator, front-end operator, back-end operator, producer, software provider, cloud provider, platform, installer, data provider, employer, insurer, or commercial and technological unit members. Fourth, identify the liability basis: strict operator liability, strict product liability, fault-based liability, vicarious liability, contract liability, data damage liability, statutory liability, or criminal conduct-based liability. Fifth, ask what evidence is needed: logs, maintenance records, update history, sensor data, model outputs, system documentation, incident reports, cybersecurity records, training records, risk assessments, contractual arrangements. Sixth, ask whether the burden of proof should be adjusted. Is the system opaque? Does the defendant control the evidence? Was a safety rule violated? Is the activity highly dangerous? Is the harm severe? Is there a clear information asymmetry? Seventh, ask whether there are multiple tortfeasors. Can the victim identify the exact cause? Is there alternative causation? Do the providers form a commercial and technological unit? Should they be jointly and severally liable? Ninth, ask how compensation will actually be paid. Does the operator have funds? Is there liability insurance? Can the victim sue the insurer directly? Is there a compensation fund? Is the technology uninsured or unidentified?
That is a complete liability map.
And the central message behind the whole framework is simple: AI complexity must not become a reason why victims receive less protection.
Or, put differently, automation should not become a liability shield, technical opacity should not become a compensation barrier, and corporate fragmentation should not allow companies to escape responsibility.
Exactly.
Thank you, Daniel.
Thank you, Emma.
And thank you to everyone listening. This has been Law, Technology, and Society. See you next time.